Module 6. Copyright, Plagiarism and Referencing. All researchers must be mindful of the copyright laws to avoid any infringement on these laws. There are grievous penalties upon any infringement. Therefore, as a researcher, you must adequately acknowledge works used during your research. This is the purpose of this module, which is to teach you copyright laws and their infringements and ways of avoiding any infringement through proper referencing and citation. Welcome to MyDan GST Noun, your one-stop channel for mastering GST and building real knowledge that works. My name is Dan Asukwo. Whether you're a Noun student, from another university, a lecturer, or just someone hungry to learn, this is for you. Make to subscribe. Unit 1. Copyright Laws. Introduction. In this unit, you will learn about intellectual property laws with reference to copyright law, the purposes for this law, and the concept of fair use. Intended learning outcomes. By the end of this unit, you will be able to explain the concept of copyright law and the purposes for this law, or explain the concept of fair use, or apply the copyright law in writing academic paper. Main content. The concept of intellectual property rights. Intellectual property rights are legal rights over creations of the mind. This law grants the author of an intellectual creation exclusive right for exploiting and benefiting from their creation. The purpose of this law is to stimulate creativity of human mind for the benefit of all by ensuring that the advantages accrued by using a creation benefit the creator. This will encourage creativity and allow investors in research and development a fair return on their investment. Intellectual property confers on individual enterprises or other entities the right to exclude others from the use of their creations. Intellectual property legal titles relate to the acquisition and use of a range of rights covering different types of creations. These may be industrial or literary and artistic. Types of protection of intellectual property. 1. Patents. This covers new, non-obvious, industrially applicable inventions. 2. Trademarks. This covers signs or symbols to identity goods and services. 3. Industrial designs. This covers ornamental designs. 4. Topography of semiconductor product. This covers original layout design of microelectronics industry. 5. Copyright. This covers original work of authorship. 6. Neighboring rights. This also covers original work of authorship but in performing, broadcasting organizations, etc. 7. Trade secrets. This covers secret business information. Protection against unfair competition. This covers all of the above. Copyright law. There is a legal framework that governs access to information enacted by the government of every country known as copyright. Copyright legally gives the creator of a work the monopoly of controlling the distribution of his work. This right is usually for a while, after which such work can be freely accessed by the entire public. In other words, copyright is the right awarded to an author for being intellectually responsible for his work. The author determines who adapts the work. Intellectual works covered by copyright law include patents, books, artwork, and trademark. In other words, if a person or an organization holds the copyright on a piece of writing, music, etc., he is the only person who has the legal right to publish, broadcast, perform it, and other people must ask his permission to use it or any part of it. A brief history of copyright. In 1710, the world's first copyright law was enacted in England, known as Statute of Anne. What this law did was to give the copyright of a work to its original owner. It also laid down fixed terms for the protection of the owner's right. Because of this act, authors were requested to register their copyrighted works at Stationers' Hall and deposit specified copies at some designated copyright libraries. After some time, other countries gradually came up with their own legislation based on Statute of Anne. For example, United States came up with the Copyright Act of 1790. However, it was not until 19th country that copyright legislation became coordinated at the international level. Although in 1886, the Berne Convention was introduced to provide mutual recognition of copyright between nation-states. Secondly, Berne Convention was also organized to promote the development of international standards for copyright protection. The Berne Convention brought world recognition of copyright law. Therefore, there was no need for authors to register their works in individual states. The Berne Convention is still in force till date and remains the basis for international copyright law. Berne Convention extended copyright protection to unpublished works after a while and also removed the requirement for registration. The implications of this, in the countries included in the Berne Convention, is that an individual, or the organization they are working for, owns the copyright of any work they produce as soon as it is recorded in some way, be it by writing it down, drawing, filming, etc. Purpose of copyright law. There are basically two purposes for the copyright law. These are economic and moral. Looking at it from the economic point of view, copyright encourages creativity. If an author gets a good reward for his work, he will be encouraged. This can happen only if that work is protected, otherwise another person, intruder, may pirate and distribute the work as his own. From the moral perspective, copyright protects the integrity of the created work by giving the author the right to object to any distortion, mutilation, or other modifications which would be prejudicial to his honor or reputation. Copyright tries to provide a balance between the interest of the author and that of the user. Copyright ensures that somehow the public has some sort of access to a created product. After all, the essence of writing is for the public to appreciate maximally. Utilize the idea for self and national development. Fair use. Copyright does not prohibit all copying or replication. The Copyright Act of 1976 permits some copying and distribution without permission of the copyright holder or payment to same. The statute did not clearly define fair use. However, it gave some factors to consider in a fair use analysis, which are the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work, the effect of the use upon the potential market for a value of the copyrighted work. It is therefore not an infringement to make short quotations from a work for purposes of criticisms, teaching, scholarship, or research. Nevertheless, the name of the author and the source of the quotation must be acknowledged duly. Self-assessment exercises. 1. Intellectual property rights are. 2. State the factors to consider in fair use. Let have your feedback on the comment section. Conclusion. The violation of copyright is a serious issue globally. However, in academics, provision has been made for fair use of scholarly resources to foster research and development, especially in third world countries. Always take note of the following. 1. Legal rights over creations of the mind. 2. The factors are the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, the effect of the use upon the potential market for a value of the copyrighted work. Hit subscribe, leave a comment, and don't forget to share with your friends, classmates, and academic groups. Together, let's make learning simple, fun, and rewarding.